All right, welcome everyone to this webinar that we're putting on for the new Property Law Act. So the new Property Law Act is coming into effect on the 1st of August. So I'm doing this on the 24th of July. So we've got a week and our new Property Law Act is coming into place. So wanted to do this and give everyone an idea about what the changes are, what they mean. Some of you have already heard me talk about this, and some of you haven't. So I'll go through it in all the detail. Um, Feel free to put any questions in the chat, and I can either answer them as I go, or there'll be an opportunity at the end for any questions as well. So just a little bit about me, for those of you who don't know, Jeremy Stretton's my name, and I've been practicing as a lawyer for over 20 years now. Uh, I started NPR Law back in 2022 to really focus around property and resumption work. We do a lot of work with property owners whose property has been resumed by the government. And But yeah, with that comes all the other property stuff that we do as well. And Before this new act comes into place, there's a bunch of laws in Queensland that govern property. So property is a state-based legislation. So one of the things, as a lawyer, I can't act in other states. I can only act in Queensland, and that's because each state governs their own property laws. So there's a number of acts that govern property law in Queensland. You've got the Property Occupations Act. For those agents on the call, you know all about that one. That regulates real estate agents and how they sell property. There's the Body Corporate and Community Management Act, which regulates strata properties. The Land Titles Act, which regulates the titles registrar system, and the Property Law Act, which is like the mother of all acts that governs everything. And the new act was passed back in 2023, and it was based on a bunch of recommendations, I believe that came out from QUT professors in the late 2010s, so around 2017. It took them that long to actually implement it. The old act was from 1974, and it just wasn't fit for purpose. We saw that through the pandemic and all the changes that we've had. So this is all about bringing the laws into the 21st century, because a lot of them were actually quite outdated. And as I said before, it's really important to note that this all comes into effect on the 1st of August, which is next Friday. For those of you watching on the 24th of July. So just be wary of that. And yeah, I'm going to go through two main areas. One is the seller's disclosure, which is the biggest change, and making sure that we're actually giving the right disclosure, because it's really, really important. I'll go through the ramifications of that. And then there's also some commercial laws that have changed around leases and some other areas as well, which I will outline. All right, and welcome those who've just joined me. If you've got any questions, as we go, feel free to put them in the chat, and there'll be an opportunity at the end to ask any questions. So let's talk about the first part, the mandatory seller's disclosure. So as I said, this is probably the biggest part that comes into place. So from the 1st of August, which is next Friday, all properties sold in Queensland, except for a few minor exemptions, which I'll go over in a minute, needs to have a seller's disclosure form provided by the seller to the buyer before the buyer signs the contract. So not before the contract's entered into, but before the buyer signs the contract. Now, there are also some what they call prescribed certificates that go with the form. And those, the main two that have to be provided on every single one, every single seller's disclosure, are the title search, so a current title search for the property, and the registered plan as well. That needs to be provided as well. So, as I said before, there are some exemptions to this. So the exemptions are basically if you've got related parties that are transferring property. So, if they're related under the definition under the Act, you don't need to provide it. If you're selling to government and listed companies, then they don't need it as well. If it's to do with a boundary realignment, they don't need it. And if there's high value transactions, so if the sales price exceeds $10 million, you don't need to provide the disclosure. However, the buyer needs to waive the requirement for that. So what I'd say is there are there are some other exemptions where the buyer has to waive the requirement rather than you just don't have to do it. And what I'd strongly recommend, if you're not sure, you think one might apply, or someone tells you that it does, talk to us first. I'm happy to answer any questions and just make sure that it works, because we all need to get used to this new regime and the new act. The other ones are family court orders and court orders requiring transfers and transfers after death. There is also some rules around option contracts, which you need to basically put into place. But again, yeah, I'm not going to go into great detail here about those, but I'm just going to say is if there is any option contracts or any questions, and someone says, "Oh, I don't need to provide disclosure," please just come and check with us first. Like, I'm happy to answer any quick questions. And the last category is if the local government if the local government is selling because someone hasn't paid their rates. So that's the other situation. I will go through the form in a moment, but there's a few other points that I want to make around the form. So I mentioned before you have the form and the prescribed certificates, and I'll go through in a moment. There are, in certain circumstances, other what they call prescribed certificates that need to be attached to the form. So I will go through that. But the title search and registered plan go on every single disclosure statement without exception. Okay. So let's talk about how we provide the disclosure document. So we provide the prescribed form with all the attachments to the buyer before they sign the contract. Now, who can give it to them? The seller can give them the form too. The real estate agent can give them the form too. The solicitor acting for the property owner can give the form too. And any other person who's authorized by the seller. Now, how do you actually give it? And this is probably the more important part, is you can either give it to someone personally, so hand it to them, leaving it at or posting it to their last known place of business or residence. Interestingly, though, just given how slow Australia Post is these days, if you post it to somewhere, you've got to leave 7 days before they sign the contract for it to be deemed to have been received. So the same as if you post it to the registered office if it's a company. Probably the most used one now, especially in 2025, is going to be electronically. So, it's probably the easiest way is to send an email to the buyer or send it to the buyer through DocuSign or whatever electronic signing platform that you have. Because the buyer, and I'll show this when I get to the end of the statement, the buyer should sign the disclosure statement. And you want them to do that before they actually sign the contract. So, what a good practice would be going forward, and I've spoken to a number of agents around this, is that we do we send them the disclosure, they sign that, and then we send them the contract. Then there can be no questions that it's whether or not it's being provided. If you're going to do an auction, then it needs to be displayed or given to the bidders. But sometimes at auctions you can have unregistered bidders. So it's probably best to display it and provide it to the bidders. Because as soon as that hammer falls, I'm sure everyone's aware, once the hammer falls, the contract is formed. And so we need to make sure that they have it before the auction. So anyone who does auctions need to talk to us about that beforehand. So all of the disclosure can be provided in one hit, or it can be provided over multiple emails. I think that the best course of action and the standard practice should just be sending it to them all in one hit and having the ability for them to find it. When I talked about electronic before, one thing I didn't mention was that I know that some agents in particular will send buyers like a pack or access to a Dropbox link or a Google Drive that has a bunch of documents relating to the property. If you do that and you want to prove that the buyer's seen it, then you need to prove that that document was in the packet and in that folder at that time. So again, I think it's much easier if we just make sure that it all gets signed and the buyer signs the acknowledgement, and then there can be no question. Now, if you don't provide the disclosure, if you don't provide the disclosure or that there's an error in the disclosure, there are consequences. So if you don't provide the disclosure or some part of the disclosure, then the buyer can terminate the contract up until settlement. Once settlement occurs, they obviously can't rescind the contract or go back on it, but they can terminate the contract up until the date that it's or the actual settlement that actually occurs. So once that's fine, once that's done, then it's fine. So that's if you don't provide the disclosure or don't provide one of the prescribed certificates. If there's an error in the Form 2 disclosure, there is some nuance to what actually will happen here. So the nuance is that it's not an automatic right of termination. What the buyer has to prove is that a reasonable person, so on an objective basis, that a reasonable person would not have proceeded with the transaction if they had received the disclosure. So it materially affects the ability to buy the land. So this is obviously new law. With new law comes problems as far as enforceability and interpretation. Obviously, we wouldn't want to be taking any test cases to court to try and define what that was unless it was absolutely necessary. So we want to make sure that we get this right from the beginning. So what I might do now is talk about the prescribed form. So I'm just going to change what I'm sharing here. Let's change to the seller's disclosure statement. So you've most people have probably seen this before. So this is the form that comes into effect on the 1st of August. Just on the timing of this form, there's some argument because the legislation doesn't come into effect until the 1st of August, that if you have the seller sign it before the 1st of August, which some people might do to try and be proactive, that it's not actually a valid form. And again, I wouldn't want to be the first one to try and test this in court, but what I would say is that you have the document ready. If you know that someone's going to want to sign a contract on Friday, have the seller's disclosure ready and provide that on the day and get the seller to sign it because you actually got to sign the form. So because of just the way that legislation works and when it's enacted, it's not actually valid to give disclosure until the law comes into effect, which is the 1st of August. So there's a few little what are they, transitional problems that can arise. So let's go through the form. So in the Act, it prescribes a bunch of information that you can provide to a buyer, and that you must provide to the buyer, I should say, and a few statements. So everything is incorporated in the form. You have to use the form. Don't try and do your own one. Use the prescribed form. So it has a standard warning. You must be given the statement before you sign the contract for the sale of the property. So this is the buyer. Importantly, these things aren't included in the disclosure. And I think it's a really important point to drive home. If you're a buyer, you still need to look into the flooding and natural hazard history for the property. You still need to get a building and pest inspection done of the property. And if you've got questions around its structural soundness, you still need to go and get that looked at and make sure that you're happy with it. Current or historical use of the property, you have to provide the current zoning of the property, but the use of the property doesn't need to be disclosed here. Current or past building or development approvals for the property don't need to be provided. Limits imposed by planning laws on the use of land. Services that are or may be connected to the property, especially in new developments, then that information is stuff that you need to find out. And then I reckon this is a pretty important one: the presence of asbestos within buildings or improvements on the property. So if you're a buyer, you need to do your own investigations to make sure that you're happy that those things are there because they're expressly excluded from this new form that we have to provide disclosure on. If you're aware of some of these things, you may want to provide that information anyway, just to make a buyer comfortable with the purchase, but you don't have to. So let's get into the actual form. So you've got to give the name of the seller. So that's the name as it appears on the title. So sometimes you might have a married couple where the wife bought the property in her maiden name, and she's married and she's changed her name. If that isn't changed on title, this needs to be the maiden name, the property address, and the lot and plan. Pretty simple. If it's part of a community title scheme, then you need to disclose that. Your community title scheme, probably 99% of community titles are the community titles, and then there's a bookta scheme which is older body corporates, and there's certain disclosure you got to give around those. So you need to give a copy of the title search and the registered plan. So you got to tick, and the form is all interactive. You can tick it on. I know that they're going to come up with different versions, so I actually just downloaded this one today. So this is the latest one that and it's actually they haven't really changed it for a couple of months. So then registered encumbrances. So this is really important. When the Act was first passed, it talked about actually that the seller had to provide copies of any registered encumbrances. So this might be easements or the deed of grant on the property. It indicated that you had to provide that. That's not the case now. They've actually changed that. So any copies of any documents like easements, statutory covenants, and leases and mortgages, that's for the buyer to find on the title search. And if they're interested, they can have a look at them. Obviously, if they're buying a property and it's got an easement, they want to know what the easement is. And that comes on the buyer to do their own searches. And I'll just make a point now on that is that this disclosure document doesn't change the buyer's duty and the solicitor acting for the buyer to actually do their own research into the property. Just because you're being provided with searches doesn't mean that you don't, as when you're acting for the buyer, actually provide that do that search again because you want to verify all the information on here. So then we've got unregistered encumbrances. So this is an interesting area. So uh, you've got to disclose if there are encumbrances that are not registered on title. So what might they be? They might be unregistered leases. They might be other agreements in relation to the land that isn't a lease. So it might be something to occupy the land, like a license to occupy the land, or something that you want to go over to a buyer. And then any other oral agreement. So most of the time, the only thing that would be included here is the unregistered lease. Um, for a residential property, you'd include those details in there. So the start and end date of the term of the lease, the amount of rent and bond payable, and whether the lease has an option to renew. You'd include that information, but you'd also include that for a commercial property. Often we don't register leases for commercial property, so all that information needs to be in there. And if you've got multiple tenancies, you just create a schedule and put that information in there. If there's an oral agreement where someone's, verbally agreed to, lease a property or to allow someone access through the property, that needs to be disclosed there too. If it's not, then the buyer isn't buying the property subject to that. So that's really important that if there is anything there, that's disclosed. Then I think one that often gets overlooked is statutory encumbrances. So statutory encumbrances are the things like water pipes, things that go through your land that you may not even realize are there, depending on how long you've owned the property for. So you can find out most of that information through a dial before you dig search. There's also a new tool that's come out with InfoTrack that lets you it's about $90 and lets you do a search of your property to see whether or not there are any of these statutory encumbrances through the property. I think that's something that most people will need to do unless they're confident when they bought the property that there was no statutory encumbrances there, because that is something that could really affect a buyer's ability to use the property. For instance, when I grew up in Wilston, and at the back of the property there was a statutory easement for a sewer line. So the sewer line ran at the back of the property. That meant that you couldn't build anything on the property for quite a substantial area. My parents bought that back in the 70s, all this disclosure wasn't there. But if that was bought now, this would need to be disclosed because a buyer might want to put a shed on the property. And if the statutory encumbrance is there, then they can't do that. So we've got to do that. I mentioned I misspoke before. I talked about leases up here. That's only for commercial ones. If it's residential and tenancies, put it there. Although in saying that, it's there's no harm in putting it in both places because the more you disclose, the better. So then we get into land use planning and environment. So the zoning. Now, you've got to disclose the zoning of the property. Now, I understand that InfoTrack, who've built probably the main tool around this, is putting. They told us earlier in the week that they're partnering with a organization to work out this zoning. You can find out the zoning of any property by going to the local government website and basically searching the property address, and it will tell you what zone it's in. They're going to bring that all into one tool that will do it all for you. But you can easily get that information from the council website. There are those special exceptions and areas that have different rules on it. So things like Sanctuary Cove, there's a couple of apartment blocks in the city that have certain rules around what you can and can't do as far as zoning goes, that also need to be disclosed. So if it's in a special unit, then it's probably worth looking into that as well. That won't come up very often, but when it does, it's important to get both the council zoning and what the actual legislation around that development says. Next one is quite close to my heart, which is transport proposals and resumptions. So under the put it on there. Oops. Under I'm not too sure how to change that. Anyway, under the current contract, you've got to disclose any potential resumptions for your property. A lot of people think that they can get away with not doing that. So if you've received an actual notice of resumption, then you've got to disclose that. You've got to provide a copy of that. What happens though, and this has just recently happened for a bunch of streets in Morayfield and Burpengary East up near my office, they've received letters from Transport and Main Road saying that they think that they might require the land, and and that they're investigating it at the moment. If that's the case, then you've got to disclose that, and you've got to provide a copy of that letter. So there was an argument in the past that you didn't have to. Now you 100% do. So that's a question that a property owner should know the answer to, whether they've received any letters. If they aren't sure, you can do a TMR, so Transport and Main Roads search on that. But that's only Transport and Main Roads. So the different councils can also resume land. Unity Water or the other water authorities can resume land. The federal government can, although they rarely do. So there's other government bodies too. And I think the really important thing here is talking to the property owner about the consequences of not disclosing it. The consequence of not disclosing it is that the buyer can terminate the contract up until settlement. So if they choose not to tell you, then that's on them, and that information doesn't go. If it's not in there, then that would be a material prejudice. Contaminated and environmental protection. So most properties aren't on the register. There is a search you can do. Again, a seller should know whether or not their property is on the EMR or the CLR, because when they bought the property, it's a standard search that all lawyers should do to make sure that the property isn't on the register. If they're not sure, then there is a search that you can do to make sure that it's not on there. There are some other complicated, disclosures that you've got to make. I'm not going to go into all of those, but if the property is affected by some sort of Environmental Protection Act rule or it's subject to a management plan, all of that needs to be disclosed. For the agents here or someone who's preparing this without the assistance of a lawyer, that's the time to get a lawyer. Talk to the lawyer and make sure that you're disclosing the correct things, because these things don't come up very often, but when they do, they can cause lots of pain for a seller if a buyer terminates the contract. Next thing to disclose is if there's a tree order or an application under the Dividing Fences Act, then you've got to disclose that. And if there's an actual order and application, then you've got to give a copy of that. So that's another prescribed certificate that becomes a prescribed certificate. The same as, I should have said that here, any resumption notice needs to be there, and any contamination also needs to be disclosed too. If the property is affected by the Queensland Heritage Act, then that needs to be disclosed. And you'll see here too that this is part of the form that you don't have to disclose flooding. I think part of the reason for that is that flooding is it depends on the event and what actually happens. So they don't want to make you have to disclose if there was some flooding and whether it was creek flooding or runoff flooding or something else. So we want to make sure that the buyer knows to check that themselves. Vegetation, so koala habitats, all that doesn't have to be disclosed. But if you think that might be a thing, then you should. There are free online searches that you can do with the government agencies to check that. And any buyers, any solicitor should be able to do those searches. So let's get into part 4, buildings and structure. So this is once again saying that the seller doesn't warrant the structural soundness of the building, and that it is still upon the buyer that if they're concerned, they should go and do their own inspections on the property. What you do have to provide is if there's a pool on the property, then you've got to provide the pool certificates or the pool safety compliance certificate or the no pool safety certificate. So you actually have to provide one of those two, and if you don't, then again the buyer can terminate, and that's part of the standard contract anyway. Unlicensed building work. So this is the owner builder section. So you've got to disclose if the property had any work done to it under an owner builder permit in the last 6 years. That should actually be registered on title as well. And there's certain disclosures you've got to do around that too. And the platforms that have been built, so we use InfoTrack, and I believe the REIQ is partnering with InfoTrack as well. They actually help produce the right documents here as well. There's a small fee for it, but it does it all for us and make sure that we get all the right notices out there too, because you've got to comply with that. Building energy efficiency certificates. Then that's just a saying that if it's that big that you need to provide the certificate and where you get it from. And then just going back to asbestos, which I said before, That's something that if you're concerned about asbestos, that you should get a asbestos report, because you actually then have to get a management plan for the property. This is probably more so for a commercial property, but some residences still have some asbestos. I know my house that I bought, oh gosh, 15 years ago now, we found out that there was a shed in the back that had asbestos after we bought the property. That doesn't have to be disclosed. I have no idea whether the seller knew, but it's something that you should check in as well. Now, next one is that you've got to disclose the current rates and water. These should be, you should be able to get this information from the clients, the property owners' rates and water notices. Now, one of the things that's really important here is that you can also do a search, but that takes time and it also takes time, and I don't think it's 100% necessary unless the buyer just has or the seller has no idea about this information. And I was going to say, and it's costly as well. So you insert the amounts of rates. That should just be off the last rates notice, the dates range, and then the water as well. Now, if these amounts are wrong and they're not significantly wrong, then that is in the Act. It actually specifies that that isn't a material matter that the buyer can terminate. So if it's really wrong, if you say it's $100 and it's really 2,000, then that might be a different story because it might change whether or not someone would buy the property. But it's say if it's done and it's slightly erroneous or the rates have gone up because the local councils and the water people love to up their rates, then that's not a reason for them to terminate the buyer to terminate the contract. But you still got to put in the latest information that you have. For body corporates and book schemes, you've got to disclose that there. Again, you've got to provide a copy of the community management statement. So that is a registered document with the titles office. So you've got to provide that, and that becomes another prescribed certificate under the Act. So you've got to provide a copy of that. Now there are new body corporate certificates, a new form that you need to provide, and they've actually one of the great things about this is that they've with the change is that they've introduced a more streamlined process to get these certificates. And I know through InfoTrack, there's now the ability to order a certificate at a reasonably standardized price across the board that will set out all of the information that's required. And it's all done electronically through there. Uh, and if you say if there's some reason why you can't get a body corporate certificate, then you need to disclose why that's the case. That shouldn't happen very often, but it does happen from time to time. So that is something important to go into that. It goes into the statutory warranties. If you've got an older property, then you need to provide the information, for the Bugda scheme. But they are, that was an act back from the 1980s. So there's not that many properties that are still on that. And I mentioned this before, the seller signs this. I think that it is prudent to get the seller to sign it, that agents and solicitors shouldn't be signing this. The seller, and if there's more than one seller, they should both be signing it. If there's more than two, just put another signing page in there. They should be signing this, naming, dating it. And then importantly, and I know I'm repeating myself, but I think it's important, is that we should get the buyer to sign it and make sure that we've got a documented trail to show that the buyer signed this before they signed the contract, and they got all the other documents. So the tools that we've been provided with, InfoTrack, actually compiles all that together and actually gives you all the tools for you to use that. So that's the form two. That's the big form. I'm happy to help out, and if anyone needs any help with putting those together, I'm happy to help put those together and make sure that they're done correctly. Because I do not want, for the sake of a 5-minute conversation with any clients, there to be a mistake that could have easily been picked up if we looked at it. So please reach out to us. If you want to start getting some together before next Friday, happy to look at anything and make sure that we're going forward. So that's the form, and that's the big change. But there are other changes that are coming in for the 1st of August. The next one is new REIQ contracts. So everyone on the calls would be familiar with the fact that there are a bunch of different contracts right now for residential house and land, residential in a body corporate, commercial in a body corporate, commercial just standalone, and there's all these different contracts that are out there. The REIQ has released, or at least the Queensland Law Society has released to us, the new contracts. So there is one residential contract for all residential properties and one commercial contract for all commercial properties. I understand that there was some talk about them actually combining it all into one contract. I'm quite glad that they haven't done that, because I think that would be confusing. But there's one residential and one commercial contract. I'm not going to go through them today because that would take too long. They are very, very, very similar to what was previously provided in the contracts and all the information. They're just all consolidated into one form. Again, if anyone needs any help filling those out, please let me know. I am happy to do it. I'd much prefer to fix it before there's a problem than otherwise. And one of the things that our insurer, the Lexon, who was the lawyers insurer for Queensland, has made clear is that they don't want us preparing Form 2s, so seller's disclosure, without also advising on the contract at the same time, because the two are interlinked. So what we would say, what I say is I'll have a look at both the seller's disclosure and the contract to make sure that it's all right. Because at the end of the day, that's the disclosure that we need to make sure that buyers can't get out of the contracts. Otherwise, there's no point of having a contract. All right, so they're the changes to contracts. If there's any questions, put them in the chat, and I'll answer them at the end. So let's talk about the other changes that are coming in. So probably the other big area that are changes are around leases. So most people on the call are probably aware that there's an act called the Retail Shop Leases Act that regulates retail shop leases. And then the Property Law Act, the one from 1974, actually applies to commercial and industrial leases. And basically anything that isn't a retail shop. So the new changes that are coming into place are around commercial and industrial, and basically anything that isn't a retail shop. Now, one of the interesting parts that always happen when they bring in new acts is around what happens to old leases when the new regime comes into place. My understanding of the act is that if you enter into a lease before the 1st of August, the old regime applies. If you enter into a lease after the 1st of August, the new regime applies. I think that's the simplest way to look at it. However, there may be cases where there might be an argument that an extension of lease might be subject to the new act rather than the old act. So again, talk to us about it. Make sure that we get this right, because there's a bunch of the different transitional provisions that would take hours to go through, but we'll make sure that we get it right. So let's talk about what the big changes to commercial and industrial leases are. The main one is around assignment of leases. So this is where a landlord has to consent to, or has been asked to consent to the assignment of the lease from one tenant to another. So a lessor now has a prescribed time of 1 month to consider the consent. Before, there was no time. Most of the time when we do it, it's a much faster process than that. But if a lessor hasn't come back about the consent within 1 month, then the tenant who wants to assign the lease to someone else can apply to court for an order that the landlord has to give consent. And obviously the court will look at the terms of the lease. They'll look at the conditions of consent to make sure that the tenant actually does that. Hopefully that doesn't actually come up because it seems like an unnecessary cost. The tenant still has to provide all the information that's required under the lease. Yeah, we've had some recently where tenants have and their solicitors have quite strenuously objected to information that we've requested. There's no rule about what you can ask and what you can't ask, and that information ends up being provided anyway. Importantly, and I think this is probably with the difference between old and new leases, whether they're entered before or after the 1st of August, is where you have a lessee and a guarantor, then you can, the way the law is right now, you can keep that lessee and guarantor liable for the rest of the lease term. Say if it gets assigned another 10 times, that original lessee and guarantor can still be liable for the original lease because they entered into the arrangement with you in the first place. So that's always been the law. That's not the case in retail shops. You have to release them. But in the commercial lease now, when the assignment is done, the first time the assignment is done, you can bind in the lessee and the guarantor, so the assignee and the guarantor. But if it's assigned again, then you can't, that original lessee and guarantor are no longer bound. So it's something to just consider. And whether that applies to old leases or new leases is going to be an interesting dichotomy. Yeah, and that doesn't happen too often, but it is something that does come up from time to time and something to be aware of going forward because a lot of landlords like the security of keeping the tenant and the guarantor liable. Just let me have a drink of water. So the next section that's changing is the breach of lease provisions. And this isn't a big change, but it's just important to note. And again, this is one of those things, hopefully breaches of lease don't come up too often, but when they do, make sure you run any new processes past us before you go ahead. So you still got to give the notice of remedy breach of lease. But depending on who's registered on the title and in the lease, you have to give a copy of that notice to everyone. It used to be the case that you just had to give it to the tenant, but say if there's a mortgage over the lease, you've got to provide it to them. If there's receivers or managers appointed over the company, you've got to give it to them. If there are guarantors, you've got to give it to them, and sublessees, you've got to give it to them too. Let's face it, when you have a breach of lease, you want everyone to know about it so that it can get sorted out, unless you're trying to get rid of the tenant. Most of the time you want to do that. So you want to get out, you want to get the notice out to as many people as you can. Now, the other big change here with breach of lease is this comes up from time to time with our landlord clients, is that say if a tenant leaves the premises, just packs up their stuff, closes the door, you used to have to give like a reasonable time, like a notice with a reasonable time for them to go back in there. No longer required. If someone just, and if you've got, sorry, let me go back to that. If you reasonably believe the tenant has left the premises, then you can retake possession straight away. You don't have to wait for the breach of lease process. Again, hopefully that doesn't come up, but if it does, it's a good change to have. And they've also changed some of the circumstances where a lessor can refuse to renew a lease because of a breach. There's some very nuanced law around this because the way that it was previously was there was a blanket rule that if the lease said uh, that if the tenant had breached the lease at some point in the past, then the lessor could refuse to grant the renewal. The new law changes that so that it's not as black and white as that. I'm not, again, it's one of those things that it's very nuanced and it's going to be very much on a case by case basis. But if you're looking at a lease renewal and the tenant's been in breach of the lease and you're wanting to use that to stop them from being able to renew the lease, talk to us about it first and make sure that we're getting that right because yeah, it is very much a case by case basis. So they're the main changes that are coming into leases. There's a last section I want to talk about around other changes. Now, these are things that probably don't come up for most people, but they're interesting to know because they may come up in the future. So let's talk about deeds. So there are different types of contracts, and one of those types of contract is a deed. A deed is a certain type of contract that you can form without any money changing hands. So the term is consideration. So normally for a contract, you need an offer, an acceptance, and consideration. A deed is a form of contract where no consideration has to be paid. There are certain requirements on that. Part of what came in around COVID was that electronic deeds were allowed. So you're allowed to sign them electronically. That's continuing. A shortening, though, of the limitation period. So a deed used to be able to be enforced for up to 12 years. It's now 6 years. And also guarantees and indemnities, they've modernized the rules around those to make sure that everyone understands that they can be signed electronically. Again, this is a good thing. I think everything we're doing is signed electronically, and there's a lot of transitional provisions that came in over COVID because of, yeah, obviously we weren't able to meet in person. But now these are now in the new act that lets us do that. Now, the next one is against a little nuanced area of the law that hardly ever comes up. But there are some easements where, because of the way that they were worded, an easement wasn't binding on a subsequent owner of a property. So if you had an access easement that was worded a certain way, then and you transferred one of the properties to someone else, that easement wasn't binding on that person. That's now changed to make it very clear that all easements, especially the ones registered on title, are binding on both parties no matter who owns them. Nuanced area of the law that doesn't really apply to most people, but it's an interesting one to know just in case something comes up around an easement. And the last change is around installment contracts. So an installment contract is a contract that's entered into between a buyer and a seller, where the buyer makes a payment before settlement that is and so they make a payment that is not a deposit under the contract. So what that might be a non-refundable deposit. It might be a part payment of the purchase price. That makes the contract an installment contract, and that gives certain rights to a buyer that a contract can't be terminated. Now, um, the Act has cleaned up one of the definitions around this, and that's around what I said before around the non-refundable deposit. And yeah, it used to be arguable. I always thought it was pretty clear cut, in my view, on in the cases that I read, that if it was a if you had a non-refundable deposit that made it an installment contract. Now that's actually very clear in the legislation. It is an installment contract. Again, it doesn't come up very often, but it is an important thing to know. They've also updated some of the rights to the buyer, but the most important one is, and hasn't changed, as if you have an installment contract because you may have a non-refundable deposit or some other payment, you can't terminate on the date of settlement if the buyer doesn't settle. You have to give them another 30 days to be able to settle. Doesn't happen very often, but if you don't do that, then it can actually mean that the buyer can terminate because you're repudiating the contract. Again, there's some nuanced law around this, but it's important to know if you think that that might apply, come and talk to us. We're happy to help out. All right, so I've gone through all the different changes that are or the most relevant changes, and I want to open up for any questions if anyone's got any. You can either come off mute or you can put something in the chat. I want to give opportunity for any questions if I haven't been clear enough about something.
Uh, Jeremy Lawrence here,
Hey, Lawrence.
fellow solicitor as well. How you doing?
Very well, very well. Good to have you on here.
Yeah, thanks for going through that. I just wanted to. The reason that I joined was just to see if another colleague would concur with my opinions or view otherwise.
Yeah.
Um, but I guess the first question I want to ask, the vegetation. So in the form two, and
Mm,
as you correctly pointed, that if there's any some sort of vegetation information about the property, the seller must also disclose.
yeah.
Um, Lately, with a lot of newly developed property, a lot of my clients, they've actually acquired it, and then there's obviously a vegetation notice or a vegetation, or usually there's a vegetation notice registered on the title.
Yep.
Um, my question is, do you think that, let's say in future we need to sell a property, a client needs to sell a property that there is a vegetation notice registered on title? Do you think that we actually need to obtain a dealing and also disclose that?
Well, it makes it quite clear in the form and the stuff I've read that if it's registered on title, you don't need to actually provide a copy of it. What I would say to that is that there's going to be a lot of nuance to this and fights where like bad situations make bad laws, in my view. And so I would err on the side of providing it if you have it to the other side. But if it's registered on the title, then generally speaking, it doesn't need to be provided. So, but I would just provide it anyway, generally.
Okay. No,
Just
thanks
because,
for that.
like, why open it up for a dispute if you can just provide it?
Yeah, no, fair point. Very fair point.
Cool. Any other questions, Lawrence?
I'm just ticking it. Oh yeah, you also mentioned about if there's some inaccuracies based on the search and rates provided. Which section of and it wouldn't preclude, it wouldn't allow the buyer to terminate if there's some small inaccuracies in terms of the rates of the water, the amount of the
Yeah,
rates of water
it's in the
that.
regs, in the regulations.
Yeah, I thought
Okay.
that was the
Yeah,
case.
yeah,
Yeah.
it's in the regulations. I can't remember the exact regulation, but it's in the regulations.
No.
That was in the Law Society Roadshow as well. They talked about that too.
Yes.
Obviously, you can't be wildly wrong, but if it's just a little bit wrong, then that's fine. Cool. All right. Thank you. Any
Thank
other
you.
questions? Everyone else but my fellow lawyer is going to give me a break on the questions. All right. Well, if you've got any questions, we will send out a recording of this. Obviously, I've recorded it. So if you've got any other questions that come up or any issues as we're going through this new regime, because remember it does start next Friday, please feel free to email us, and we will make sure that we help out and get and yeah, the last thing I want to happen is any contracts be terminated because of something that we could have solved earlier on. Thank you, Chris, for your comment. Thanks, everyone. Yeah, if you've got any questions, just email us and we're happy to help out. Have an awesome day, everyone.
Thanks, Jeremy.
Thanks, Curtis. Thanks, everyone. Ruth or Lauren, did you have any questions? Stop recording for